We're hearing case number 24 CR 240, State of Ohio versus Jesse Smith. We're here for final hearing on the state's motion to terminate community control sanctions that was previously filed. The defendant previously waived probable cause. And as I indicated, we're here for the final hearing. Defendants in court with counsel Ms. Nicolette Tomasic. Ms. Tomasic, what is the defendant's intentions at this time regarding the final hearing?
Yes, thank you, Your Honor. I spoke with Mr. Smith. He indicated he would like to waive his right to have his final hearing. He is willing to admit to the allegations today, and we're prepared to proceed to sentencing, Your Honor. Thank you.
Mr. Smith, you've been charged with violating the conditions of your community control sanctions. Specifically, there's 3 alleged violations. The first is a Rule 8 violation, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged on April 24th you tested positive for marijuana. The next allegation is a Rule 1 violation, which requires you to obey all local, state, and federal laws. And it's alleged that on May 8th, you were cited for driving under suspension by the Cleveland Heights Police Department, and you pled guilty to that offense on June 12th. It's further alleged another Rule 1 violation, and that on June 26th of 25, you were arrested by the East Cleveland Police Department and charged with domestic violence. Now, you have the right to have a final hearing regarding these allegations, which is a hearing where the state would be required to prove the merits of what they're alleging. Now, you can have these hearings, but you can also waive the hearings and plead guilty. Your attorney has indicated she believes you want to waive the hearings and plead guilty. Is that correct?
Yes, sir.
Well, before I can accept your waiver and your plea, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If, in fact, that were to occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 36 months in the lesser included offense of count 1, 18 months in the lesser included offense of count 2. That would be consecutive, so 54 months or 4.5 years in prison. You understand the potential penalties you face if you're found to have violated your community control sanctions? Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violations?
I'll like to waive it, Your Honor.
Very well. As the Rule 8 violation for using marijuana back in April 24th, what is your plea to that?
I want to plead guilty.
As to the first Rule 1 violation for having been arrested and convicted of driving under suspension in Cleveland Heights, what is your plea to that? And for the last Rule 1 violation, it's strictly for being arrested. It's not for, I know the case is still pending, so I'm not having you admit to the actual offense or conduct, but for being arrested by the East Cleveland Police Department and being charged with domestic violence, what is your plea to that? Okay. So that can't be used against you, just so you know that.
I understand. I appreciate it.
All right, I'll accept your plea, find that you did violate your community control sanctions. Ms. Tomasic, any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We would like to ask the court today to allow Mr. Smith an opportunity to continue probation. This is his first probation violation within this court. I know he did have a review hearing back with his probation officer.
What do you mean it's his first? Everybody says that. It's like you're entitled to 1 or 2. You're not entitled to any.
I know, Your Honor, I know. I had an opportunity to speak with Mr. Smith regarding NeoCap. He indicated to me, after explaining to him a little bit more what NeoCap entitles and what the benefit is, he is actually interested in going to NeoCap. He thinks it'll be very beneficial for him. Your Honor, he has been trying to work on himself. He has been actively applying for jobs. He said he's had a difficult time due to the felonies. He has had a couple interviews. he did have an opportunity at a factory job, Your Honor, but then he did get picked up on these domestic violence allegations in East Cleveland, so he no longer has that opportunity. I know he does have a fight set up for tomorrow. He's fully aware that he likely will not be attending that fight. He knows he needs to get a different type of employment for himself. He has been living with his grandma during the past year or so, but due to the allegations, he indicated to me he's planning to move back in with Mom, so she is a good support system. Mom actually is here in support. So we just like to ask the court for an opportunity to allow Mr. Smith to continue probation. If Your Honor would see fit, allow him an opportunity at NeoCap because he does think it would be beneficial. Thank you.
Mr. Smith, you have the right to address the court before you're sentenced. You can say anything you like. Is there anything you want to say?
I just want to say, after sentencing me to JTP and my weekly conversations with David Tompkins, it does help me being a better father, a better brother, and a better worker and athlete as well. I have been on a straight line besides.
You have what?
I have been on to things that I said I would be doing, as in trying to find a job, staying on a straight line. I have, like I said, I've been guilty to these charges, so there is that. But I will say, being on the probation with Lake County and talking to Dave Thomas and having JTP has very much so helped. And
Well, how's it helped? You tested positive, picked up a new offense, you arrested him, another pending. He hasn't cleared up those warrants at all, has he?
No, Your Honor.
I told him that was supposed to be done immediately.
my Cleveland Heights warrants, I actually went into court and I'm paid off for now $400, if I'm not mistaken. But I think I've been in here, so I missed my last.
What about the Parma warrants?
I was trying to get the money in so I could work to pay them all off. It was $560. I didn't have it, so I paid off. Started with Cleveland Heights first, so I could work my way to Parma. And actually, I was supposed to go to Parma, and all of the sorts happened. It's been kind of hard to go money-wise because I've been working temp agency jobs here and there, landscaping, all of the sorts of
The warrants, you can't be out and about with warrants on you on probation. I mean, whether you get them taken care of, they'll do whatever they do, and then you take care of them. They're not.
Understandable.
Well, you say that, but here we are 7 months later, and those haven't been addressed at all. I mean, you got a huge break here, Mr. Smith, with the charges that you were originally charged with. Not only that they didn't charge the firearm spec, they reduced the charges. And you got to get a job. I know you're into the fighting, and that's great. But you got to get a job.
I actually talked to Dave about that a month ago. I had this fight signed up now for about a month and a half. Me and him had a conversation. I was going to give it up for at least a year so that I can work. That was my choice. This fight has been lined up only because I signed the contract, but my choice was to give it up for about a year so I could be able to work and focus on working in my child.
Hey, Dave, can I see you for 1 second?
Yes, sir.
I'm sorry, Mr. Smith. Is there anything else you would like to say?
No, Your Honor. I appreciate you for hearing me.
Ms. Thomas, is there anything else?
Nothing further, Your Honor.
All right, well, I've reviewed the original pre-sentence report and investigation. I've considered the facts and circumstances of the original offense which brought us here initially. nature of those offenses. I've considered the defendant's performance on probation, the nature of the violations, and everything that's been said here today. All this is considered under the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I'm going to incorporate all the findings I made originally regarding the seriousness factors and the recidivism factors with the additional finding today that the defendant has failed to comply with the previously imposed sanctions ordered by the court, which is a factor indicating recidivism is more likely. Despite the violations, I will give the defendant one additional opportunity to make this work here on community control sanctions. But there's really going to be nothing left for me to do here if this doesn't work out. I'll continue on community control sanctions. I'm going to order you serve 86 days in jail with 26 credit. I will order, however, that as soon as a bed's available at NeoCap, that you be released from the jail to enter the program at NeoCap and successfully complete that program. Not sure exactly how long it will take to get in, so we put the 60 days on there, which should be more than enough. If there's a bed available next week, you'll be released. Don't count on that necessarily, but if there is, but as soon as that's available, you'll be released to go there. The rest of whatever time is remaining will be vacated. If you successfully complete that program, follow their aftercare recommendations. After NeoCap, and you're probably not going to have to do this, but there's going to be an order that you return to the jail for 30 days for the transitional day reporting program. And again, you probably won't have to do this. But what the transitional day reporting program, it's a program that allows, or assists, I should say, people making the transition from being locked up to being on their own. Many people, after they've been in custody, have nowhere to go when they get out. They'll open the doors and say you're free to go, and they have nowhere to go or nothing to do. But if you have housing lined up, you have work lined up and ready to go, I'll vacate that. Otherwise, you do it, you're released. What the program is that you're in the jail, but you're released during the day to look for housing, look for work, get everything lined up. As soon as you get it, the rest of the time is vacated. So it's a good program to help people. So I put it in place for everybody. The rest of the conditions are going to be the same thing that you've had. You're not to use any drugs or alcohol. That includes no marijuana. So submit random urine screens. They must be negative. Positive screens of violation. To attend 3 AA meetings a week and have a sponsor. You're to obtain and maintain full-time employment or education or some combination of the two. Did it ever have the mental health evaluations, the psychological and psychiatric?
It was going to Cleveland Clinic for a lot of this mental health stuff.
Okay. We'll continue with your mental health counseling. Take all medications as prescribed. Pay your court costs and supervision fees. I think I said it, but I'll say it again. Resolve the outstanding warrants. Mr. Tompkins, anything else I should consider?
I don't believe so, Your Honor.
So, Mr. Smith, you understand all the conditions of your continued probation?
Yes, Your Honor.
Any questions for me? I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, and the East Cleveland thing won't count. That's already been taken care of. So however you resolve that will not impact your, if you think it's in your best interest to plead guilty, I'm not saying you have to do that, but you can do that without worrying that it's going to affect you here. That's been taken into consideration here. All right? But if you commit some new act going forward, if anything like that should happen, a motion to terminate your community control will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 36 months on count 1, the lesser included offense of count 1. 18 months in the lesser included offense of count 2. Those terms would be consecutive for 54 months, and that would be consecutive to any other new case you maybe pick up and get sentenced to that you're serving at that time. Mr. Thomas, is there anything else for the record?
No, Your Honor, thank you.
All right, thank you. Good luck. We're hearing case 24 CR 100, State of Ohio versus Eric Work. We're here on a motion for a probable cause hearing on a motion to terminate community control sanctions. Defendant is present in court with his counsel, Ms. Nicole Novotny. Ms. Novotny, what is the defendant's intention at this time?
Your Honor, at this time, my client's intention is to waive both hearings and admit to the violations forthwith.
Mr. Work, you have been charged with violating the conditions of your community control sanctions. Specifically, there are 4 alleged violations here. The first is a Rule 10 violation, which requires you to submit random urine screens as directed by your probation officer. You are not to alter or tamper with your urine sample. Your refusal to provide a proper sample is a probation violation, and you shall not have in your possession a device or substance to simulate a urine sample, nor bring with you a urine sample. And it's alleged that on July 28th, you submitted a urine sample that tested at 110 degrees, making it invalid, and that you then acknowledge that you submitted a urine screen other than your, a urine sample other than your own. Next violation is a Rule 8 violation for which prohibits you from using, possessing, or having under control any controlled substance not prescribed to you by a licensed physician. It's alleged on July 28th. You self-reported that you used marijuana, quote, 3 weeks ago. There's another Rule 8 violation, which alleged on July 29th you submitted a urine sample that tested positive for cocaine, opiates, and fentanyl. And there's a third Rule 8 violation. And then on July 29th, you self-reported that you had been using Percocet for the last 3 weeks. He didn't get violated for having the items on him when he went into the jail?
No, Your Honor, I did not violate that.
So, Mr. Work, you understand the 4 violations here?
Yes, I
Any
do.
questions about them?
No.
Now, you have the right to have a couple hearings regarding these allegations. The first is a probable cause hearing, which is a hearing where the state would be required to present some evidence that would suggest you probably committed these violations. You then have the right to have a final hearing on the merits, and that would be on another day and time to give you time to prepare if that was what you wanted to do. And that's a hearing where the state would have to be required to prove the actual merits of what they're alleging. Now, you can have either or both of these hearings, but you could also waive both hearings and plead guilty to the violation or violations, and your attorney has indicated she believes that's what you want to do. Is that correct?
Yeah, I want to be held accountable and move on past it.
Okay. Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to violate your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, which could include an order that you serve more time in our Lake County jail. Or I could terminate your probation and send you to prison. If I did that, it could be 9, 12, 18, 24, 30, or 36 months in prison on count 1. Count 2 is the misdemeanor. Any jail time on that would have to be served concurrent with the prison sentence. So you could get up to 3 years in prison. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, I do.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive both hearings and plead guilty to the violations?
I'll waive both hearings and plead guilty.
Very well then, as the allegation that you submitted a urine sample other than your own to the probation department, what is your plea to that?
One more time, sorry.
As to the allegation that you violated Rule 10 by submitting a urine sample other than your own, what is your plea to that?
Guilty.
As to the first Rule 8 violation for using marijuana, what is your plea to that?
Guilty.
As the second Rule 8 violation for testing positive for cocaine, opiates, and fentanyl, what is your plea to that?
Guilty.
And as for the third Rule 8 violation for using Percocet, what is your plea to that?
Guilty. I mean, those two kind of run together, but
You're saying the Percocet's the reason for the
yeah,
positive?
I told them, you never know what's in those things
Yeah.
anymore.
Fair enough. So you thought you were, that's fair enough. I mean, those two are, in my mind, combined together.
Okay.
Marijuana is obviously something different, but. All right, the court will accept your plea, find that you did violate your community control sanctions. Ms. Novotny, any reason not to go forward with sentencing?
We may go forward, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. We would just request any type of leniency the court to consider at this point in time with regard to any type of prison that may be imposed. We would ask the court to consider the minimum prison with the result in this case with that respect. With regard to Mr. Work, he has been doing very well from my understanding on probation besides this point in time. From my understanding, he just recently lowered from a high level of probation supervision to a medium level of probation supervision just based on how well he's been doing with probation. With that respect, I know during this time he has went through a downward spiral, felt trapped at that point in time and ultimately relapsed, Your Honor. He fully admits to that. Ultimately, with our conversations, it was a way of him trying to stop what he was doing. And ultimately, he wants to take responsibility for everything that has happened with that respect. Your Honor, when he was out, he was working at Chagrin Tavern. He's a line cook. He's been there since he was out and since the last time that you've seen him with that regard. He received 2 promotions in that time, so he was doing very well when he was gainfully employed, Your Honor. He does have 2 children. They're older. They're 20 and 18. He has been going to Signature Health with regard to counseling, as well as for his med compliance. He does feel remorseful for his actions here. He'll later explain that to you in full detail with that respect. I know he does have family support here today with regard to these matters. We're just asking for any type of leniency with this matter, Your Honor, and to consider if prison is imposed, any type of minimum with that respect.
Thank you. Mr. Work, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah.
Go ahead.
Sorry, I stand up.
Whatever you're comfortable doing.
Okay. Well, first I want to apologize to you personally for the way I was the last time I was in front of you. I was real disinterested, aloof, just kind of arrogant about it. Didn't have a whole lot of remorse, but doing the programs and stuff that you put me through. When I got out, I did start repairing my relationship with my father. I was doing really well for 18 months. Started my job the day after I got out. I know there's not supposed to be any violation, so I'm not going to sit here and say this is my first one, but I don't want this to reflect negatively on the probation department. Nicole and Kaylee did give me the tools. This is 100% on me. I really just hope you give me some leniency so I can try and get my life together. And I apologize to my mother and my family. Thank you.
This court has reviewed the pre-sentence report and investigation and considered the facts and circumstances of the underlying offense, the nature of that offense. Consider what's been said here today. Consider the defendant's performance on probation, nature of the violations. All this is considered like the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, I'll incorporate all the findings I made at the time of the original sentencing hearing regarding the seriousness factors and the recidivism factors with the additional findings today that the defendant has violated previously imposed sanctions ordered by the court, which is a factor indicating recidivism is more likely. Can I see Kaylee and Nicole up at sidebar for a second, please? It's not on the record, Mary. All right, I've already put all my findings on the record here. Certainly at this point, with the nature of the underlying offense, quite frankly, and the violations, prison is consistent with the purposes and principles of sentencing. The question is whether you're amenable to available community control sanctions, and I'll be honest, Mr. Work, when I came out here, I was planning on sending you to prison. The person I remember is the person that was here a year and whatever that was. And you were an ass back then. You were. You weren't respectful. I mean, you were respectful, but you weren't. You were a jerk.
No, I was totally a jerk. Your Honor.
You're not coming across that way today now. Maybe you're putting on an Oscar-winning performance. I don't know. But if you're fooling me, then you'll be back here, and it'll be worse for you. But this is not how you presented yourself last time. And the fact of the matter is you've been on probation for 16 months. 15 months before all this happened, maybe even a little short. It sounds like you maybe been using for a couple months before this all started. But you've done well. So I'm willing to give you another chance to get some treatment and continue if that's what you want to do.
Yes.
You do want to do that?
Yes. I just want to be the best version of me I could be for my family.
Well, I will find that you're amenable to an available community control sanction. Hang on one second. I'm not going to terminate your community control sanctions. I am going to extend it by 6 months. I'm going to order that you serve. How much is on the PV? 5 days, you said?
Yes, Your Honor.
I'm going to order that you serve 65 days in jail. You have credit for 5 you've served. I am going to order that you enter and successfully complete the treatment program at either Lake House or Concord Pines as soon as a bed's available. So once a bed's available, you'll be released from jail, and you'll be ordered to go to that program. Any jail time that is left from the 60 remaining days. What's that?
He was just asking a
You don't have to
question.
tell me what he's asking. I just want to make sure.
I
was
was asking if those programs would let me go to work so I can let my boss know, because he did say I have a job.
The residential programs. Well, eventually he does, doesn't he?
I think it's over some time. From what
Yes,
she-
Your Honor, not
I-
right away.
Not right away, but eventually, if you're doing well,
Just so I know what to tell him.
I think I'm not sure how long that is. You'll find out. But these are through Lake Jog, and I know that eventually they want that. They encourage that. It's part of the program. So, enter the residential treatment program at either Lake House or Concord Pines. Successfully complete that program. Follow all aftercare recommendations. Upon completion of Lake House or Concord Pines, you are to reside in a sober living residence for at least 6 months. You can stay longer if you want, but at least 6 months after you complete the program, you're to reside in a sober living residence. All the other conditions will remain the same. Not to use any drugs or alcohol. You must submit random urine screens. They have to be negative. You can't tamper with the samples, bring in fake urine, any of that. If that happens again, you're going to get the maximum. Well, you're going to get the maximum sentence. You're to attend 3 AA meetings a week and have a sponsor. Have you been getting mental health counseling?
Yes, I have, but my counselor was on maternity leave the last 2 months. I think that kind of contributed to my slide. I didn't reach out though, so I mean that's on me.
Well, I want you to continue with mental health counseling, any psychiatric counseling, take all medications as prescribed. 1 doctor, 1 dentist, 1 pharmacy, same thing. You already did your anger management?
Yes.
Okay. Pay your court costs and supervision fees. Kaylee, anything else I should think about here?
No, Your Honor.
So, Mr. Work, you understand all the conditions of your continued community control sanctions?
For the sober living after Concord Pines or Lake House, do I have to pay for that?
I don't know how that works.
I'll figure it out then.
I think you do pay a,
It's like rent.
huh?
Paying rent somewhere.
You pay rent somewhere?
Okay, cool.
But you go out and work I mean, you're working and everything.
Yeah, I will have a job when this is all over, so, thank you.
Well, that's a condition also, if I didn't say it, obtain and maintain full-time
Yeah.
employment. Do you have any other questions?
No, thank you.
All right, I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you were to commit another new crime while on probation, a motion to terminate your community control will be filed. And if it's found that you did violate, I could extend your probation technically up to a total of 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it'd be 36 months on count one. And if we do come back here for a violation, it's going to lean more, it'll be towards the higher end. I can assure you that, with the break you're getting here.
I understand.
All right. Mr. Novotny, anything else?
No, Your Honor, thank you.
All right, good luck, Mr. Work.
Thank you.
Honor, before you today on E. Amin, file 25 CR 403, we're here today for a change of plea. It's anticipated by the state of Ohio that the defendant withdraws previously under plea of not guilty and under a plea of guilty to count 1 of the indictment, which is trafficking in cocaine, felony in the 5th degree. In exchange, the state of Ohio will ask this court to acknowledge the remaining charges. Other than what's been spread upon the record, no threats or promises have been made to this defendant to induce this plea. And I'd also like to advise the court the defendant's new case did in fact come forward, and I provided discovery to Mr. Watson, and we have an agreement for an information. We'd ask that the court, along with sentencing on the case before us today, set that for a change of plea sentencing.
Well, if an information is filed prior to the sentencing, I'll do that. I'm not going to push back the sentencing date longer for that, but if the information gets filed, I have no problem setting the information for a hearing and then doing the sentencing for both cases on the same day. We can just incorporate the PSR from this case into that one. But
Yeah, because it's the request and everything's already complete.
as long as it's filed before the sentencing date.
No problem.
Okay.
Thank you, Your Honor.
Mr. Watson, does that all sound correct?
Thank you, Your Honor. May it please the court, that is my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I do believe full discovery has been provided. I've also had a chance to discuss this matter with my client, Mr. Hameen. He is prepared to enter a change of plea as just outlined. He understands that by entering a change of plea, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. And Mr. Hameen, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe you want to do at this time?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previous enter plea of not guilty to count 1 and plead guilty to that count. The other 2 counts would get dismissed. We would defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing, where there's no agreement between. There's no agreement, right? So you
No,
said
Your Honor.
no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I am going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Well, let's get started then. How old are you, sir?
What was that?
How old are you?
43.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, you would have been served with and received a copy of this indictment. It looks like you got it around the beginning, middle of June sometime. That's the document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes.
And at some point, did you have the chance to look that over?
Yes.
Now, in that indictment, you are charged with 3 counts. You're pleading guilty to 1 count, count 1. And in count 1, what is alleged here and what you'll be admitting to is on or about October 31st, 2024, in Paynesville Lake County, Ohio, that you did knowingly sell or offer to sell cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams. It was 0.69 grams, which makes the offense trafficking in cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about it?
No.
Now, there are two other counts in this indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about those two charges?
No.
Right. Actually, I have to do quick. What was count 3 about this theft of $100 from the narcotics agency?
It was a controlled buy that was set up. He took the money and left and never provided the drugs.
So that's why there's $100 restitution there?
Yes.
So it's not money that was spent on an actual buy, because you can't get restitution for that.
It was the buy money that was provided to him. He said he had to leave, and then he never returned and wouldn't answer the calls from the confidential informant afterwards, so he stole the money.
Right. So I guess I saw the restitution in the paperwork, and but back in the day, we used to always order restitution for the money that the narcotics agency was out for buying drugs, and court cases came back and said you can't do that. So I saw your restitution here, and I was wondering why it was there. Now I understand. So it's not because that money was used to purchase drugs; it was actually stolen.
It was stolen.
Okay, gotcha.
Thank you, Your Honor.
All right, so you understand count 1, the charge you're pleading guilty to.
Yes.
Well, before I can accept your plea, then I need to make sure you understand the rights you are giving up. And you, first of all, have a right to a trial. And a trial could be me as a judge, or I would listen to the evidence and I would make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to have a trial?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility, he bears the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of this charge, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state has presented at trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you can ever be found guilty of that charge. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the prosecutor would call witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He could ask them anything he wanted to, but within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request this court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision, that is a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if you went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
You understand them all?
Yes.
You still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. You understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as potential sentencing goes, you're pleading guilty to a felony of the fifth degree. This is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, are you currently on probation or parole or any type of supervision in any other courts?
No.
Obviously, you have one other case pending. Do you have any other charges pending aside from the one that was just bound over?
No.
So in that other case, the discussion is that you're going to, they're going to work out some type of agreement and you're going to plead guilty and be sentenced at the same time as you will on this case. I need to advise you that if a prison sentence is imposed in this case and that case, I could run those sentences either concurrent or consecutive to each other. Concurrent means together, that you'd serve the sentences at the same time. Consecutive means one after the other. You'd serve the sentence in this case, whatever it is, finish it, then you'd serve the sentence in that case. You understand the difference there?
Yes.
Okay. I'm not required to do that, but I need to let you know that I have the discretion to do that. You understand that?
Yes.
Okay. Now, if a prison sentence is imposed in this case, upon your release from prison, you could be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be for up to 2 years. You understand that?
Yes.
And if you were put on post-release control and you were violated any of the conditions of your supervision, parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
You could also I can also suspend your driver's license for up to 5 years. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face by pleading guilty. I did use the word possible because prison is not required or mandatory with this charge. You are eligible for probation or what's called community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you're automatically going to be put on probation? It means I'll consider that if that's what you're requesting. I'll look at all the information presented to and provided to the court. Then I'll make the decision I think is the right thing to do. You understand that?
Yes.
Now, if you are put on probation, it could be up to 5 years of supervision. As the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you are put on probation and you violate any of the conditions, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve jail time. Or I could terminate or end your probation and send you to prison at that point. And if I did it at that point, again, it could be anywhere between 6 to 12 months in prison, and that could be consecutive to any other prison sentence you may be serving at that time or you're being sentenced to at that time for another case. Do you understand that?
Yes.
All right, lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider, your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand all that?
Yes.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I don't think it's the right thing to do. Do you understand that?
Yes.
All right, will you have any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes.
You still want to plead guilty?
Yes.
Have you had enough time to discuss this case with Mr. Watson, have him go over the reports with you, discuss the issues, answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering this plea freely and voluntarily?
Yes.
All right then, Mr. Hameen, any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions? Do you need any more time to talk to your lawyer before we go forward with the actual plea?
No.
All right, then what's going to happen at this point is the prosecutor is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him because then I got some questions for you about that, all right? All right. Mr. Geigerich, count one, please.
Thank you, Your Honor. The evidence would show that the defendant was targeted by Lake County Narcotics by way of a confidential informant. A deal was set between the defendant and confidential informant to occur on October 31st, 2024. The deal was set for 1 gram of cocaine for $100. The deal did in fact occur at 201 Richmond Street in the city of Paynesville, Lake County, Ohio. The narcotics that were recovered were sent to the Lake County Crime Library to test positive for cocaine Schedule 2 in an amount of 0.69 grams. Thank you.
Thank you. So, Mr. Hameen, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we did have a trial?
Yes.
And what, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Very well then, regarding count one, charging with trafficking in cocaine, a felony of the 5th degree, what is your plea to that count at this time? All right, I have in my possession at this point document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this over with Mr. Hameen, explain it to him, answer his questions?
Yes, Your Honor. I did have an opportunity to review the written plea of guilty with my client. I read it to him. He read along with me, indicated he understood it. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Hameen?
Yes.
Do you understand what the document says?
Yes.
Any questions for me about it?
No.
That was indicated and it does in fact appear in the document that you signed it. Did you sign it?
Yes.
Mr. Geigerich, you witnessed that as well?
I did, Your Honor.
All right. Well, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court. With his lawyer advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, trafficking in cocaine, a felony of the 5th degree, violation of 2925.03A1. Counts 2 and 3 will get dismissed at sentencing, but sentencing will be deferred. I'm going to order a pre-sentence report and investigation. You requesting anything else?
Well, Your Honor, based upon the charges, specifically the plea by information coming up, I would ask.
Yeah, what is that charge?
That would be a F5 drug possession, Your Honor.
Yeah, I'll do a drug and alcohol evaluation
Correct,
as well.
Your Honor.
Is that all that is? One count that's getting bound, or that you're going to do, that the case is?
Correct, Your Honor, for the plea by info,
Okay,
correct.
that's what I meant, yeah.
Yeah.
All right, so I'll do a drug and alcohol as well. I'll continue defendant's bond and owner cognizance. What all this means, Mr. Amin, as far as bond goes, there's nothing more you need to do. You've already signed your bond form. I need to remind you that an OR bond, owner cognizance bond, means you have to show up at all future court dates, and your failure to do so is a separate felony that you can be prosecuted for, separate and apart from this. So it's obviously important you show up at all future court dates. Do we have a sentencing date? Do you know, Mary?
I don't know.
Amy, are you listening to me here? Well, I'm going to get it before you leave.
Do you want me to just go ask her?
Sorry? Yeah, let Mary go ask her. I want to put it on the record.
September 8th at 1:15.
All right, so Mr. Amin, the next hearing date, which is the sentencing, is September 8th at 1:15. So you need to make sure you're here on that time. If not, obviously a warrant would be issued, but then new charges could be forthcoming. Now, the reports I've ordered is so I can learn more about you and get an update from the last time you were here. It's important that when you meet with them that you're open and honest with them. Probation, that meeting, so they're going to check and verify everything you tell them. If they learn you're misleading them, they'll let me know. That report needs to be completed in order for me to be able to consider probation as an option. Without a report, the law doesn't even allow me to consider probation. And in order for them to do the report, the interview with you must take place. So it's important you show up on time when scheduled at probation for that interview. You understand all that?
Yes.
And one of the conditions of your bond has been and will continue to be that you don't use any drugs. You have to submit urine screens if requested. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. You understand that?
Yes.
All right. So you're going to leave here right now. You're going to go to the probation department. We're going to give them a paper, right, Mary?
Right.
We're going to give you a referral sheet to bring over with you. You're going to go there, fill out some initial paperwork, and then get your dates to come back. So make sure you do that, all right? You know where that is?
I'll walk them there, Your
Okay,
Honor.
very well. All right, Mr. Geigerich, anything else for the record?
Nothing, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
All right, thank you.